Good morning, everyone. We're going to go ahead and get started. Jason, thank you. We did hear you, so we are good to go. Again, good morning, everybody. I am Erin Turvitt, the communications lead with the Department of Workforce Services here in Cheyenne. We cover the entire state of Wyoming, and I'm thrilled to welcome you to today's virtual training series, Building Better Workplaces, Navigating Wyoming's Labor Standards and Compliance. This series, the virtual training series, was created based on your feedback, and we're super excited to bring you topics that matter the most to you. Be sure to check out our website at dws.wyo.gov/VTS, that's virtual training series. We'll drop the link in the chat just right now for you for upcoming sessions, registrations, and recordings of all the past events. So today's session is going to be recorded, and all materials are going to be available on our website within a few days. So if you do have questions during the presentation, just pop them in the chat, and Jason will answer them at the end as we go through. Jason, I'll go ahead and interrupt you when I see a question come through, and we'll just handle it that way for you.
Right.
Okay. Now let's go ahead and dive in. Please welcome me and join me and welcome. Oh my goodness. Sorry, everybody. It might as well be a Monday. Please join me in welcoming today's speaker, Jason Delo, Labor Standards Manager for the Department of Workforce Services. Welcome, Jason.
Thank you. Appreciate everyone being here this morning. And go ahead and dive in. Like I said, if there's any questions, just throw them out there. We'll try to deal with them as they come up. Okay, so just kind of a brief go over of what we're going to be handling today. I'm going to introduce you to labor standards, kind of understand workplace discrimination, go over some wage and hour issues, and walk you through some an analysis of employee versus independent contractor. Labor Standards administers a number of programs in the state. The primary ones are the Fair Employment, Wage and Hour, Child Labor, Prevailing Wage, and Resident Contractor Certification. We do outreach in all areas of enforcement. We'll talk about, people want to have questions about things. People want to know something about something they've seen in the news. They're more than welcome to come in and have us speak on the topic. We do some consulting. If you want to throw a employee handbook our way and kind of see if there's any issues with it. We can't give you legal advice, but we can certainly let you know if there's anything that looks like it might violate a known statute or rule. We also do training on harassment prevention and correction. So if you're interested in that, again, just get a hold of us and we will set something up. Starting off with workplace discrimination. There's some key elements you need to understand in order for something to be illegal workplace discrimination. First and foremost, you have to have a adverse employment action of some kind. It needs to be against an employee. It needs to be based on a protected class of race, sex, national origin, age, religion, or disability. Adverse action can run the gamut of things, starting from hiring on all the way up to discharge, including things like harassment, demotion, discipline, failure to promote, failure to accommodate. Kind of the sky's the limit in what that can entail. There are four federal statutes that we deal with. The Civil Rights Act of 1964, the Age Discrimination and Employment Act of 1967, and the Americans with Disabilities Act of 1990. Variously, these all protect folks from discrimination based upon their race, color, sex, national origin, age, religion, and disability. The fourth one I mentioned is the new Pregnant Worker Fairness Act, which provides additional protections to pregnant women, including the need to accommodate some pregnancy-related issues that would otherwise not be considered disabilities. So when we're talking about creating a fair workplace, we're talking about people being aware that it can happen, making sure that people are trained on what to do when it happens, or if it comes up, having good, solid policies that would help help people navigate how to get how to help people navigate the process, and then robust enforcement, making sure that if you do find workplace discrimination, you're dealing with it appropriately. In addition to the federal statutes, labor standards also enforces the Wyoming Fair Employment Practices Act of 1965, which protects folks, again, based on race, color, sex, national origin, age, religion, and disability. It also protects people from being discriminated against because of their use of tobacco. Folks may remember, oh, it's been a long time now. There was an epidemic of employers firing folks because they smoked, because employers felt it was driving up their employee health insurance, and they were getting rid of folks that they feared would cause problems for them. Wyoming was proactive in that and decided that no, you can't fire somebody because they simply smoke or because they chew, as a way to lower your insurance premiums. We don't see a lot of that, but it is an additional quirk to Wyoming law. Okay. In order to file a charge of discrimination with Wyoming labor standards, you have to come to us within 6 months of the last act of discrimination to have state coverage under the state law, the WFEPA, or to us within 300 days to have coverage under the federal laws. You can certainly consult with an employment attorney if you want to. Our process, however, does not require it, and folks can come to us pro se with their complaints.
Jason, I'm going to interrupt real quick. We have a question. When we were talking about smoking, does this
Yes.
also apply to vaping?
It applies specifically to the use of tobacco. So depending on what they're vaping, yes or no.
All right. Okay, thank you.
We're going to go over sex discrimination. And the reason we do that is that the sex discrimination kind of sets the stage for everybody else. It kind of provides a good example of what's happening in other forms of discrimination, how it's handled. When we're talking about sex discrimination in the workplace, we're talking about gender stereotypes, people having an aversion to having a particular gender in the workplace. We're also talking about sexual desire, includes sexual orientation and sexual identity now, thanks to the U.S. Supreme Court. It does not cover genital horseplay or coarse language, coarse behavior. It's not a general civility code. When we're talking about religious discrimination, there is a proactive element to that in that employers must provide a religious accommodation provided it does not prove an undue hardship to the employer. An employer can't have any preference for a specific religion over another. Private employers can welcome religious items and certain practices into the workplace, but they have to allow them on an equal basis to all religions that may want to come in. When we're talking about religious accommodations and religious discrimination, we're talking about firmly held beliefs of the individual employee. It's not just a social preference or a political preference. It has to be something that's truly held to as a religious practice. There are some disability protections out there for folks under the ADA. It generally protects folks who either have a disability, have a record of disability, or have been regarded as disabled. In order to have a disability, you have to be substantially limited in a major life activity, such as walking, sitting, seeing, hearing. It also includes bodily functions like normal self-growth, so things like cancer are considered kind of per se. disabilities now. It also includes mental health conditions like depression. Epilepsy is not really a mental health condition, but it includes things that are episodic, like epilepsy, where a person may not have an epileptic seizure for long periods of time, but because they have it and it is disabling when it is active, they may need accommodations for it. Again, kind of the idea of sexual harassment, kind of setting the framework for harassment in the worst place. It is an unwelcome conduct, and that conduct can be just about anything. It doesn't have to be necessarily purely romantic or sexual in nature. That creates an intimidating atmosphere for an individual because of that person's sex. There are two forms of sexual harassment. There's quid pro quo, which is this for that. That generally has to be a situation where someone in a position of power or authority over another employee requires some sort of sexual favor or sexual activity in order to either avoid a job detriment or to attain a job benefit. The other one is called hostile work environment. And again, it's that area where they just make things unpleasant for somebody because of their sex. In general, a single act of off-color behavior or comment would not constitute a hostile work environment, the exception being touch. A single act of unwanted touching, depending on where it is, can instantly rise to the level of a hostile work environment. Again, the types of harassment cover the gamut. You can have based on religion, based on sex, age, race, cultural norms, things like that. As long as it's based upon one of those protected classes, if it's aimed at somebody to try to alienate them, it can become a form of harassment. Okay, any questions on what is harassment, what is unlawful under the Fair Employment Practices statutes?
We have not seen any questions come through just yet, so I think we can go ahead and move on.
Okay, so how do you respond to harassment in the workplace? If it's you as an individual, if you're there as the employee being harassed, the first step is to confront the harasser about it. Let them know that it's unwanted behavior and that you feel it's being done to you because of one of your protected classes. If the behavior persists and the person isn't taking the clue that, you know, when is not stepping back when you've confronted them, you need to elevate it. You need to take it to your manager, to your HR folks. If it's your manager that's doing, you need to take it to their boss. You need to escalate it. You want to make sure you are documenting any incidents that you are experiencing. You want to have dates, what happened, who was around, who may have seen it, what was happening, the context of any comments or actions that may have taken place. And then you also want to kind of take a note of when you reported it to somebody, what you told them, when, and again, who else might have been around. Once you've reported harassment to the employer, they have some responsibilities they have to take up. They have to conduct a thorough and fair investigation into the allegations, and they have to take adequate and effective action to end the harassment if they find it is in fact occurring. And that means,
Jason, I do have some questions that have popped up in the last couple of minutes.
Sure.
Okay. The first, what happens when someone is being discriminated against in the promotion process, or it's a hostile work environment, but it is not under one of the protected classes or situations?
if it is not happening because of an individual's protected class, because Wyoming is an at-will employment state, it is not illegal. An employer can treat you differently from other employees in all manner of processes that are unrelated to the protected classes. And if they're doing so, I mean, it's not right, it's not great, but it's not illegal.
Thank you. Thank you for that. The next one, religious items in the workplace. When you say private employee, does this mean non-government employee?
Yes.
Okay, wonderful, thank you. If somebody has a disability, for example, they're at work and the supervisor, brand new supervisor just started and is saying, hey, you're not disabled and you can do the tasks that I'm asking you to do. They say they're going to push them because they know they can do more. How is that going to be handled?
Okay. So again, you kind of follow that process we outlined, let them know that, no, this is actually a disability. And these are the limitations I have. If you've already got an established accommodation in place, you might, let them know that and refer them to your human resources folks, because they'll probably have a record of that. Ideally, if you have let your employer know you have a disability, someone would apprise a new supervisor to that and to let them know that, these are the accommodations in place. If not, if the person continues to push it, again, elevate it to their supervisor, to the HR folks, and let them know you're experiencing this kind of harassment, and that you need your accommodations respected.
Very good. Okay, looks like maybe, nope, we're not at the last. We have, is it considered harassment if it is not related to age, sex, or disability, such as one person is just being generally mean or degrading to another?
Again, if it's not happening because of one of those protected classes, it's just a personality conflict, it's not illegal. And they can do that if they want.
All right. Is the employer required to report back to the victim how the situation has been resolved?
No, the employer doesn't have to take the action that the employee who made the original complaint wants them to take. They just have to take adequate and effective action to end it. And they don't even have to report back to the employee that they did it. I would say, though, that in a lot of the cases where we get folks filing charges against their employer, when we get into the investigation, we have found that the employer acted appropriately and didn't kind of circle back at least a little bit to the employee that made the complaint and say, hey, we think we've dealt with this. You don't have to tell them how. They can just let them know it's been dealt with, and if they experience anything further, to let the employer know about the new actions. It can save them a lot of headache from having to go through an investigation if they've kind of just let that employee know, even on just kind of a basic level, that things have been handled, that you think you've handled things.
And then this might be the last one for right now. And I think maybe after I ask this one last question, we'll move on, and we'll probably definitely have time for more questions at the end on harassment. We do have a lot to cover, I know. So this last question: what if someone is being harassed, but they're uncomfortable confronting their harasser, but wait, I'm not 100% sure. What if someone is just uncomfortable confronting their harasser, but they do go to their supervisor? Can we just move on to employer responsibility at that point?
Yeah, I mean, if you don't feel like you can confront the harasser, it won't do you any good. Taking it to the employer would trigger their obligation to do something about it.
Okay. All right. Let's do this one last question about disability. If it is not disclosed upon hiring that the team member has a disability, but later claims to, could the supervisor ask the team member to connect with HR? And do they have to provide proof of disability?
Okay. So yes, they can actually put the employee through their process for requesting an accommodation. Once an employee has disclosed that they have one and it isn't affecting their work performance, the employer can make limited medical inquiries. And ideally, what they would do is send the employee back to their doctor with a list of the essential functions for that particular position, asking the physician to say, all right, can they perform these essential functions? And if they can't, what would be some reasonable accommodations they would need in order to let them to perform the essential functions. They can't go on a deep dive into that person's disability or medical history, but they can ask some limited questions about what it is that is needing to be accommodated.
Awesome. Thank you so much. Let's go ahead and move on for now.
Okay. So kind of getting back to the employer's responsibility, they take that good, effective steps. Like say, they can kind of choose the steps they want to take. It can be something as simple as just talking to the alleged harasser and telling them to stop, all the way up to discharge. One thing employers need to kind of keep in mind is if you see somebody being harassed because of one of these reasons, or someone, a third party, some coworker says, hey, I noticed that Bob in accounting's been harassed by so-and-so. Once the employer knows about the behavior, they are liable to at that point do something to stop it, or at least investigate it and see if it needs to be stopped. They don't have to have a formal complaint from the employee, and there are no magic words an employee has to use to bring up a complaint. They just have to let somebody know that, hey, there's this adverse activity I'm experiencing, and I think it's because of a protected class, and that's all they have to mention or note in order for the liability to attach to the employer. So why would you not want harassment to continue in the workplace? And this goes for all harassment, though, even the harassment we talked about that may not be protected. It still follows these kind of problematic areas. When people are being harassed, they don't want to be at work. It creates low morale, even amongst people who aren't being harassed. If they're just having to see it, it impacts the entire workplace. It leads to decreased job satisfaction. You lose your team cohesion. You lose productivity because the people that are being harassed, again, they don't want to be at work, so they're finding ways not to be at work by using sick leave, annual leave, anything they can do to kind of avoid the place. So they're not getting their job done. Ultimately, that leads to financial costs. And then if, there's a charge filed, it can lead to attorney's fees and court fees and potential settlement fees. So there are a lot of good reasons to stamp it out as soon as you know about it. So how do we create a harassment-free workplace? Again, you keep a zero tolerance policy towards harassment. You don't allow it to occur. You want to make sure your people are regularly trained on not only how to recognize harassment, but how to deal with it and what they should be doing if they feel they're the victim of it. You want clear lines of reporting. You want to know people need to know who they need to report it to, when. And that can take a lot of different forms. They just need to know where to go. You need to deal with harassment quickly and as fairly as possible. And just in general, try to keep a positive work culture going.
I do have one more question.
Sure.
If a coworker has been harassed and then bullied for confronting their harasser, what happens?
Okay. At that point, they would go back and report it to their employer. Let them know what's happened. Let them know the steps they've taken to try to address it, and leave it in the employer's hands at that point. If the employer doesn't take it up or do anything with it, that's when they would come to labor standards of the EEOC and report it to us.
Of course, and that's if it's one of the protected classes.
Yes.
Correct. Okay. We can go ahead and move on.
Okay. So just kind of knowing where harassment might take place can help you avoid it. If you have a large homogeneous workforce, where there's only a few people that may have cultural differences, that can be a good place for it to fester. If there's large power disparities between employees working together, isolated workforces, people that don't get checked on a lot by supervision, those kind of areas can allow harassment to occur and not be addressed. And again, there's some things that can aggravate it, such as coarse and discourse, allowing employees to be, you don't have to stop them from swearing, but In some cases, that can lead to other problems, as can allowing alcohol consumption or illegal drug use. So what we know from various research is that most discrimination doesn't get reported. Most people never file a charge. Most people don't ever even report it to their supervisors. And then when they do it, there's this inordinate fear that they are going to be retaliated against if they even try to let somebody else know about it. So the more that you can, the better atmosphere you can create at work, the more open an atmosphere you can create at work, the better off you are being able to get hold of the problems going on and being able to deal with them outside of a formal charge or court process. Again, how do we deal with this? You have good training, regular training, not only on what to do if harassment occurs, but on what you expect when it just comes to dealing with and interacting with people in general. You need to show from a leadership perspective, you are dedicated to the idea of keeping people safe at work, and free from harassment and discrimination. And you create that culture where everybody feels like they're included and they're responsible for making sure other people feel included.
I have another question.
Sure.
Where can we find statistics on reporting and underreporting, et cetera, things like that?
The EEOC and their website has quite a lot of that information, as they do studies from time to time on it.
Okay, that's something that, folks, I'm going to go ahead and get that link from Jason, and we will include that in the follow-up email that we send, so you know where you can find the reporting part of this. And I think we can go ahead and move on.
So any questions on fair employment? Seeing none, we'll move on to wage and hour. So back in 1938, the federal government passed the Fair Labor Standards Act, or the FLSA, setting the first minimum wage at 25 cents an hour and providing some key provisions that we've all come to know and love about work limitations on what can and can't happen in the workplace. Set work hours and had some child labor restrictions. Wyoming passed similar laws about the same time. Our current minimum wage is $5.15 an hour. It is notably less than the federal minimum wage. In cases where there is a conflict like that between the federal and the state minimum wage, you usually go with the law that provides the greater protection or the greater benefit to the employee. So in this case, you would have to, most employers in Wyoming have to follow the federal law. The real significant statute in Wyoming's wage and hour laws is 27-4-507, where it makes it illegal to pay the employee less than the agreed upon wage. And we wouldn't be seeing it. So if you tell somebody this is what they're going to earn, that is what they have to be paid. It doesn't matter if it includes non-monetary things, if it includes benefits, whatever it is, you're telling them, hey, you do this for me and I'll give you this, they've got to get that.
I have a question for you.
Sure.
If you go by the higher wage, then why is Wyoming's minimum wage so low?
That is a function of the Wyoming State Legislature. They simply haven't raised it for a lot of different reasons over the years, and until they decide to bring it up, it'll stay at 515.
Thank you.
Okay. So most of us think of the standard work week being 40 hours. And we have this, and under the FLSA, there's such a thing as overtime, where you get 1.5 times your regular rate of pay for every hour you work over 40. There are some exceptions to the FLSA for being for those folks engaged in executive, professional, administrative, or highly paid occupations. Wyoming, on the other hand, does not have any overtime law in general for most employees. So the employers don't have to pay an overtime premium under state law. It is all under the federal law. Any questions on that? Okay. Child labor. So in order to work at both the federal and state levels, a child has to be at least 14 years old to go into the workplace. Folks under 14 can work for their family businesses. That's up to the parents. If they work, and generally what kind of work they do, they can't do the hazardous occupations in the law, but they can generally do just about anything else, and the parents don't even have to pay them, honestly. There are restrictions on how long they can work when they're 14 and 15, but once an employee turns 16, all of the hour restrictions come off, and they can work the same amount as an adult, 24 hours a day, 365 days a year. There are still some hazardous occupation protections for kids under 18, but once somebody turns 18, those come off again as well, and they can pretty much do anything any other adult can do.
Jason, I've had a couple of questions related to our last topic. So for the wage and that situation, does that apply working from home when they're hired and then changing their mind to work in the office? I'm not 100% sure where that question was coming from. So
Yeah.
wage situation, does that apply to working from home when hired and then changing their minds? I'm not sure if that means the employer changed their mind and said, oh, no, you got to come back, or
So
that
yeah,
might be it.
again, that is back to that kind of whole at-will employment status. If the employer at one point said it's okay to work from home, and then later decides, hey, no, I want you to, if you're going to continue working for me, you're going to have to work in the office. They can make that call so long as they're not treating people differently based upon a protected class.
Okay, and we did get confirmation. Can they tell you to work in the office when you were hired initially to work from home? So
Absolutely.
the answer is absolutely. Great. Okay. Our next question. Under Wyoming law, you do not have to pay overtime, only if they are a federal employee. Am I understanding that correctly?
So yeah, I mean, so the federal employees don't even fall under Wyoming statutes. They are subject only to the federal rules and regs. There are some overtime rules for folks working for the state and the counties and folks working on public works projects. But beyond that, there's no state law that says an employer has to pay an employee an overtime premium for working over 40 hours. That all comes from the federal Fair Labor Standards Act. So if an employee or employer is subject to that, then they'll have to pay overtime.
Okay. So the next question, disability and lots of doctor's appointments. I'm gonna guess that is it harassment if someone makes a comment about that maybe, or gee, you're having a lot of doctor's appointments, what's wrong? Or why aren't you ever at work? Something like that.
It can get there. I mean, again, asking that once, probably not going to be unlawful harassment. If the employer is doing it and trying to implicate that the employee should not take further time off for doctor's appointments, the employee may need to seek a formal accommodation with that employer if in fact their disability requires them to go to doctors frequently.
Thank you. We're now into we might be into a little bit of both. Child labor, back into child labor. What is the allowed work time for 14 to 15-year-old?
Okay, so again, we're gonna go with what the feds put because the feds have the greater or more restrictive law. 14 and 15-year-olds are not allowed to work more than 3 hours during a school day and not more than 8 hours during a non-school day. They are not allowed to work more than 18 hours during a school week and not more than 40 hours during a non-school week. They can't work before 7 a.m. or after 7 p.m., with the notable exception being during the summer between June 1st and Labor Day. They could work up to 9 p.m. if the employer wants them to do that.
Okay, and then what are the 16 to 17 restrictions?
There are a lot of them, again, under the Fair Labor Standards Act. And so I would encourage folks to go out to the US DOL and look at them all. But generally, you want to kind of keep folks under the age of 18 kind of restricted from using a lot of power equipment, particularly anything that cuts metal, cuts wood, anything that large industrial equipment, heavy equipment such as construction equipment. There are driving restrictions. 17-year-olds can drive incidental to their work, but it can't be their main part of the job or a significant part of their job. So there's quite a few.
And we do have a brochure that we'll share when we do our follow-up email. And that'll also include the links to the DOL site. And basically, this is a brochure that goes into Wyoming and federal laws for child labor. So we'll share that as well. Do the hour restrictions for 15 and under apply when working for a family business?
Yes. The idea is that they want those kids to be in school rather than working.
Very good. Okay, I think different topic now. Can an employer make an exempt salaried employee take personal time off for working less than 8 hours a day?
In that, they might want to talk to the US DOL about. If they're, because generally if they're salaried, it means they get the same amount regardless of the quality or the quantity of the work they perform. They can have them use accrued sick or accrued vacation time to get them to what the employer thinks they need to work, or if they take time off. But if they don't have that kind of time, and the employer is still kind of docking their pay for missing hours here and there, then the employer may lose that exemption.
All right. An administrator who does not have the authority to terminate an employee without board approval, are they exempt from earning? I'm not sure if they're talking about the administrator or the employee.
If folks are curious about the employment tests for exemption from overtime, again, I would encourage you to go to the US DOL's website at dol.gov. And they have them listed out pretty specifically what has to happen in order for that employee to be considered exempt from overtime.
Okay. Okay, again, that's another, we'll make sure to get that link in the follow-up email for you guys. Do nonprofits have to follow the laws on pay? For example, like white collar thresholds that have been changing.
It's my understanding that they likely do. But again, the US DOL could help you. Again, because Wyoming doesn't define exempt versus non-exempt. We don't have that. That is purely something that's done at the federal level.
And okay, this might be a little off where we have been topic-wise right this second. A federal rule supersedes the state rule, like minimum wage, for example, correct?
Again, if the employee or the employer is subject to the Fair Labor Standards Act, they would need to pay the higher minimum wage because it provides the greater protection or the greater benefit to the employee.
Okay. So am I understanding correctly that the federal overtime law is not applicable to private businesses?
No, it would probably be very applicable to private businesses.
Okay. All right, so a company has to pay you what was agreed upon. Is that Wyoming or federal law?
That is Wyoming law.
Okay, very good. And let's revisit what I believe what you said is we need to check out the US DOL website for this answer. Can an employer make an exempt salaried employee take personal time off for working less than 8 hours a day?
Yes, in general, that's my understanding, but again, you probably want to check with the USDOL.
Okay, all right. And then back to child labor. Do the hazardous job restrictions for 15 and under apply when working for a family business?
Yes.
Okay. And what is the federal minimum wage?
Federal minimum wage is currently set at $7.25 an hour.
All right. Okay, I believe that we have hit all of the questions that have come through so
Okay.
far.
Move right along then.
Moving on.
Okay, again, here's some of the work hour restrictions we talked about. The number 2 is the state limits. That you'd have to follow in order to, under state law, but again, the federal limits are much more restrictive. Again, hazardous occupations. Again, these are the things that are hazardous under state law only. They don't want folks working on under 15 working on construction equipment, and they can't be exposed to chemicals or explosives or any other job declared hazardous by DWS. The only one that I'm aware of that we've declared is 14 and 15-year-olds can't work as electricians. Okay, again, here's the federal restrictions we talked about. They are much more numerous. And keeping in mind, the federal penalties are also more severe than the state penalties. If you were to violate a federal child labor law, you can be fined up to $11,000 per incident. And if the child is hurt as a result of the violation, the fines can go up to $100,000. So keep that in mind. Whereas compliance, it's up to the employer to keep a record of the age of the minor. We don't issue work permits anymore, haven't done it for a very, very long time. It's up to the employer to make sure that they know or have some proof of that the person working for them is at least 14 years old. Like I say, our violation penalty is $750 or 100 days in jail. The feds are much, much more severe. Special wage provisions. Both federal and state law allow someone under the age of 20 to be paid as little as $4.25 an hour for the first 90 days they work. Again, provided they're under the age of 20, and it is a 90-day calendar period. Not just the 90 days actually worked. You can find somebody to work for you for $4.25, more to you. All right, key takeaways. The age matters. If they're under 14, they can't work in most circumstances. They have those work hour restrictions. There's a lot of jobs minors under the age of 18 can't do. And again, you want to follow the stricter law, which in most cases is going to be the federal law. Any questions on child labor?
We do have some questions, but they don't seem to be on child labor right now.
Okay.
You want to answer?
Sure.
Okay. Okay, so I think we touched on this. A company has to pay you what was agreed upon. Is that Wyoming or federal law?
That is Wyoming.
That is Wyoming law. Okay. If a company owes you salary wages from August of 2023 and that company agrees that they owe you, can you force them to pay you, and how long do they have to pay you?
So in Wyoming, unless you work for a mine, a railroad, the oil and gas industry, a workshop, factory, or mill. There is no law saying when the employer has to pay an employee while they still work for that employer. The only time an employer has to pay an employee outside of those industries is when the employee separates. And it doesn't matter how, but once separation occurs, the employer has to pay for their regular payroll cycle. If they do not, then the employee can come to us and file a claim for wages. And you can go online to our website, again, dws.wyo.gov, and file the claim online. We can go back up to 2 years in pursuing those claims. So if you haven't been paid and you're no longer working for them, you can go that route. If it involves overtime or federal minimum wage, you can also pursue your claims through the U.S. Department of Labor.
Okay. Thank you. We have one, and FYI, our county, Laramie County here in Wyoming, has a curfew for minors, and everybody should keep that in mind. I'm not sure about the rest of the counties in the state, though. Next question, can a 16-year-old employee drive to the post office to drop off mail for the company? This is just because driving restrictions were mentioned. Is that something that would be out of the question?
For a 16-year-old, yeah. Maybe for a 17-year-old, if it only happened every once in a while.
Okay, but a 16-year-old is
They
an
do not want them
absolute no.
driving on a public roadway of any kind.
Okay. I have a question. How old do you have to be a dishwasher? This employer has gotten questions from kids who would like to do that job.
Depending on what they do to wash the dishes, it could be 14. If there's a dishwashing machine involved, you may want to check with the USDOL before allowing them to work.
Okay, so if it's just a sink and some soap, they're probably good to go. Otherwise, we need to check with the Department of Labor. Very good. All right. And another question, how many days do you have to pay a terminated employee? Can you pay them on their last regular pay cycle day?
Yes, once an employee separates, they pay per the regular pay cycle. It doesn't matter how separation occurs. That's just the rule.
Okay. I think that is it for now.
We're going to go on and cover a little bit about the Family Medical Leave Act. Again, this is a federal law. This is not something that the state enforces or even has an equivalent of. There are certain eligibility requirements. In general, you have to work for an employer for about 12 months and work at least 1,250 hours for that employer before you're covered by the Family Medical Leave Act. The employer has to have at least 50 employees within the 75-mile radius of where you work in order for them to be covered. If coverage exists, the employee may be entitled up to 12 weeks of unpaid leave for a serious medical issue, which can include taking care of a spouse or a parent or a child in having their own serious health condition. And it can also include things like birth, adoption of a child, family illnesses, personal health issues. Once that period is over or the employee is done with that particular health issue, when they return to work, they have to be given basically the same benefits and the same basic job and pay as they had before they went out for the medical leave.
I have a question on FMLA. What is the minimum number of employees you have to have before FMLA applies?
You have to have 50 employees within the 75-mile radius of where the employee affected works.
Okay. And if you are state or county government, does it matter?
I believe government is covered entirely by the FMLA. They don't make necessarily that restriction, but again, if there is a question, I would contact the USDOL.
One additional question on child labor. What is the youngest age to run a lawnmower and weed eater?
Okay, so the feds don't really want folks running those until they're 16. However, if the child is running their own kind of lawn business, mowing their neighbor's yard for money, they can be 14 or 15, and that's not going to cause a problem.
Okay, thank you. Am I correct in understanding that the state of Wyoming now pays 6 weeks of family medical leave and the rest is unpaid?
I am not aware of that.
Okay. Can FMLA cover the death of a loved one? Can you use it for that purpose?
I believe so.
Okay. Another person says, I have learned that the 12 months worked for FMLA eligibility does not need to be continuous. So it could be 4 months each year for the last 3 years. Do you agree?
It does not have to be continuous, but you do have to work that 1,250 hours in order for it to apply.
Okay. Okay. With FMLA, if there are several locations, how is the number of employees figured?
Okay, so my understanding is they take a look at the site where the employee who wants the FMLA or needs the FMLA works, and they draw that circle around that employee's workplace. And if there's 50 employees within that 75-mile radius, either at that workplace or within, other centers, they'll be covered by it.
All right, I believe we have answered everything that is out right now. So please continue.
Okay. Vacation pay and personnel records. So the way we work with vacation or paid time off in the state of Wyoming is through a couple of different vehicles. The first is Attorney General's opinion number 53 that stipulates if there is a vacation agreement between the employee and the employer, and the employee has to work a definite time element in order to earn paid time off or vacation. So something like you work for the employer for a year, you get 40 hours. Once that employee has worked that period of time, they are said to have earned that paid time off, and it must be paid out upon separation. It's a form of deferred compensation, unless the employer has specifically written into their policies that they will not pay out vacation upon separation, that vacation time is forfeited upon separation, and the employee has signed off acknowledging receipt of that policy, at which point the employer would not have to pay it out. Under our wage and hour statutes, the employer is responsible for keeping personnel records, including time records and pay records, for up to 2 years. We want to have that include the name, address, and occupation of the employee. We need to know what they were paid, how long they worked, what their pay rate was, all of that, and then any deductions from their pay for taxes and things like that. Any questions on those topics? Okay, moving right along. So one of the big issues in the wage and hour world is employees versus independent contractors. A lot of folks want to, a lot of employers want to define folks as independent contractors versus employees because there are some benefits to doing that economically. But simply handing an employee a 1099 at the end of the year and telling them that they're an independent contractor does not, in fact, make them an independent contractor. When we're looking at for employees, they have to have timely payment of wages. They are entitled to file wage claims against the employer if they don't get their wages. We do have that period we can go back 2 years. And we have no jurisdiction really over independent contractor relationships. So when we get a case and someone says, hey, no, that wasn't an employee, that was an independent contractor, we do a separate investigation into whether or not that employee was in fact an independent contractor. So these is kind of the legal definition. That employee is somebody under common law. That's the status of employee and employer-employee relationship. An independent contractor is somebody who contracts to do their own work independently without being subject to the control of the employer, except for the work it's actually being done, except for the result of the work. I kind of like to say is it's just a quick rule of thumb is if you're dealing with an independent contractor, you should look like that person's customer. If you're dealing with an employee, they will be reporting to you on most things. So the key considerations we look at when we're doing our investigations into independent contractors versus employees is the employer's right to control. That is one of the biggest factors we look at. Can they control the means and the manner of the work that they do? Do they know how to do what they do, or do you provide training to them? Do they have the tools and equipment knowledge to do it? Or the tools and supplies provided to them by the alleged employer. We do look at written contracts, but those are not absolute. We don't, let's say, okay, now you've got a contract with this person, they're an independent contractor. You can have contracts with employees. That's not a deciding factor. It's a factor that we do look at, but it's usually not determinative. We do look at how they're paid. Is the independent contractor billing out or invoicing the alleged employer, or is the employer telling the person at issue that this is what we're going to pay you, this is how much you make, and this is how you'll make it. And then comes the right to terminate. Can the employer terminate the relationship as in an at-will situation and not incur any additional penalties for doing so, or an independent contract relationship where they might be subjected to termination of the contract early. Again, we also look at who provides tools and equipment, who sets the scope of work, where the work is being done, who controls the premises. Is it the employer, is it the employee? Do they have their own shop, or do they have to do it on site? And do they provide any benefits to this employee or this independent contractor? Do they get health insurance? Do they get 401k? Anything like that will help us make that determination. Keep in mind that when we do these investigations, they are on a case-by-case basis. They're done for each individual worker. They're not done for a class when we do them. No single determining factor is what, okay. We use a lot of different factors. No single factor is determinative. But you want to make sure you're doing proper compliance and proper classification to avoid penalties, not only from labor standards, but also from unemployment insurance, workers' comp, and potentially even the IRS. Questions?
We definitely have some questions. And we are approaching the end of the noon hour. I will make sure to include the question and all the questions and answers in our wrap-up email that we'll send out here in a couple of days. So if you do have to jump off, don't worry, we can still get you the answers. So I'm going to go ahead and start on the answers now, and on the questions anyway, and you can get the answers. Somebody has said that the state of Wyoming will have 6 weeks of paid FMLA effective 1 January 2025 with a policy forthcoming. So we'll have to check into that, and we'll let you know what we find out. Somebody says, am I understanding correctly that if there are less than 50 employees employed, there is no FMLA to be offered?
Under the federal law, yeah.
Okay. Very good. Okay, so it would not be based on the company's total employees, just the radius to the facility that the effective employee is employed.
That is correct.
Okay. If the employer calls it bonus time off or BTO, do they still need to pay out? This is in regards to vacation time, I think, vacation pay. Do they
Okay.
still need to pay out the employee? The bonus
Okay.
time is only earned if the employee has certain requirements, such as only a few days off throughout the year, etc.
Okay. So if an employer has like a regular vacation time where you have to earn it, by working so many hours a week or so many hours a year, so much time, and they have something separate like personal time or bonus time, they would not have to pay that separate category of paid time off out, if they didn't want to.
All right. I have been asked to share that the awesome Wyoming workforce centers throughout the state have our labor law posters available. They're giant. They're like 32 inches by, I almost said feet, 32 inches by 42 inches. They're huge. They're beautiful. So stop by your local workforce center and pick them up. We will, in our follow-up email, send you information on where those workforce centers are throughout the state. Next question is, after 2 years, you can get rid of all items pertaining to a separated employee? Question mark. Does this follow Wyoming retention rules?
Okay. The 2-year requirement on retaining those records is just towards what labor standards and the labor law requires. I believe the IRS in some cases requires those records to be kept up to 7 years. So if you're curious about how long you have to retain them, I would kind of ask around some of the other federal agencies to see how long they would require you to keep them. We only require it for 2 years.
Okay. On FMLA, is the number of employees based on full-time equivalent employees or the total number of employees?
That I do not know. I would have to look that up.
Okay. All right. In Wyoming, are private employers legally obligated to give employees access to their employee file?
No.
No.
Employment records are generally considered the property of the employer. They can give them out if they want to, but they don't have to.
Okay. Can you pay an individual to clean even if they do not have a business set up?
Yeah. The difference is if they're only working for you and they're cleaning your facility using your tools and equipment and working on the timeline you established for them, they're very likely an employee and not an independent contractor.
Okay. Does an employer have to give you a pay stub that shows what deductions and taxes were taken out?
They do under both federal and state statute.
They do under both federal and state. Okay. All right. Somebody says, I was hired to work from home from a Montana company. I feel they may require me to go to the office. When I was hired, they asked if I would move to Montana, and I said I would not consider it. If they lay me off, would I be able to claim unemployment?
That would be a question for unemployment insurance, unfortunately.
And just as an aside, we will be planning an unemployment insurance virtual training series presentation later on in the year, so watch out for that. If you want to send that question to dws-communications@wyo.gov, we'll see if we can get an answer for you. Next question. We have some employees that work a 9/80 schedule, meaning that in 1 week they work 35 hours and another week they work 45. and they have every other Friday off. Am I correct in that we can make the correction so that they don't get overtime for that long week? We do pay for anything over 80 hours.
Okay, so under Wyoming law, yes, but again, you want to check with the US DOL before you do it, because their regs are a little bit different, and they're the ones that actually set the overtime requirements.
Okay. And back to child labor. Can 16-year-olds have a job that entail painting, i.e. painting walls in the building?
And I would say yes. You may want to take care with any ladders or scaffolding you may have to have them up on. I know the DOL has some regulations regarding that you might want to look into.
Okay. On the company that agrees to pay you a specific salary verbally, can that be enforced with not written records of set salary?
Yes, the agreement doesn't have to be in writing. It can be verbal. Ultimately, though, when the employee brings a claim for wages, they're going to have to prove that was the agreement one way or another. So,
And that proof would be on the employee who said, or
it would
yes?
be on the
Okay.
employee who says this is what the agreement is. So we would talk to witnesses. We would look at any other kind of information you could provide to us that shows, yeah, this is what the agreement was.
Okay. And the last, not the last, what steps can an employee take if pay stubs are not being provided?
They can contact us or the US DOL. There's not really a penalty in place for failure to provide a pay stub, but we can certainly make courtesy calls to employers to remind them of their obligation.
Nice, thank you. Overtime pay, this is a question. Overtime pay is not required if paid hourly. Is that's the question. That's a question. Is that a federal rule that supersedes the state, like the minimum wage?
Okay, so again, the rules for overtime come from the Fair Labor Standards Act, the federal law. And so if the employee and the employer are covered by that law, then the overtime rules would apply.
Okay. And then it looks like this is our last question. Will you include the new FMLA policy in your follow-up email? We will look into that and see what that entails and if that is available. The note that I got said policy forthcoming. So we will take a look at that and let you know what we find out. Jason, if you could go ahead and advance to that next slide.
Oops,
And we
sorry.
will include Jason's contact information, most definitely the dws.wyo.gov/labor standards. That's how you get directly to Jason's area and all the information you could want on labor standards. And again, we're gonna give you a lot of information in our follow-up. And then next slide. Your feedback matters very much to us. Let us know how we did. Jason, this session has been fabulous, and we've had more questions, more fabulous questions than I ever remember us having. So thank you so much for all of your time, and this was really, really a wonderful, wonderful training for us. Just as another reminder, this was recorded. We're gonna send this to you along with the slides. And if you would, please take this survey for us. Your input makes a world of difference to us. It helps us decide what we're doing next. And that would be fabulous. That link is going straight into the chat right now. In the next few days, we are going to send you an email with a whole bunch of more information. While you are completing this survey, we're going to post another link. Then this is going to allow you to register for our next presentation. We'd like you to join us on February 11th for Driving Internal Customer Service for Organizational Success. This is a presentation on the power of internal customer service. We're going to explore how to meet your team's needs, how to break down silos, how to handle tough conversations, and align goals to create a thriving and collaborative workplace. Thank you all so much. Thank you for joining us. Jason, thank you for presenting today. Everyone, have a wonderful next few weeks, and hopefully we'll see you in February.
Thank you for having me.